Based on the statement, ang, ang international law is one of the reasons why state and country are interconnected to each other because of the rules that makes them bind. Unsa man ni nga rules? Asa man ni makita? Ang the rules can be found through treaties, convention, agreement, custom, and culture and other sources. Atay tag example unsa man ni mga kwan. Ang treaties is a formal agreement of two country or many countries. One of the example of treaties that happened in our country is the Treaty of Manila, which happened on 1946, which United Nations and Philippines agreed on independence of our Republic of the Philippines. And also, it provides a framework for the conduct of stable and well-organized international relations. Unsa man nga framework or unsa man ni karon nga framework nga nahitabo? Karon na natay kuan murag we can consider is a global governance, ay global government ang United Nation. Isa ni sa example nga framework na nahimo na karon. Nga naa na karon. Based on not trash back, nagatag siya example or situation nga para mas masabtan ang international law. Imagine a small settlement with a number of properties on each of which stand one house in which lives one family. Bisaya ang pag-translate or pag-kuan, ang state represent as a family. This settlement has no common government, parliament, court system, or police force. Nga nga po ng ang international law karon. Wa tayo maingon nga kani gyud ang atong sundon nga ang kani nga government. Wala, no one above the word. The internal affair of each family as much as the border of each property are respected as inviolable. Inviolable. Ang every border daw sa every family kay di na pwede nga i-broke or i-violate sa kuan kay murag ila naman kabalo naman nga ila na o ila pud ni murag nya to. Families are predominantly bilateral relation with each other and engage sa commercial exchange of goods and services. Dire na nagsugod ang ilang rules or relation sa ilang sa every family which nag-start sa ilang needs or sa ilang mga kinahanglan sa ilang mga property or sa ilang family which halimbawa makatagdag example halimbawa dire walay gamay ang tubig supply ng tubig dire tas sa uban sa lahi nga property magdaghan nila ng tubig murag mga islag murag kuan sila kasunduan nga kami mohatag og tubig sa inyo kami ang sabot ka family murag mohatag pud og other nga supply or gulay nga para makuha nilang goods and services. And based on that flashback, magsimula kung ilang mga anak magsugod na kuan o magbulag na silang family maghimo nagyo nga mag-own na og new property kinahanglan himo sila sa every families og agreement nga kani mahilaan ni nga property. And based on that flashback, ang dispute or ang conflict mahitabo kung ang isa ka family mag-intervene sa other properties sa isa ka family. Or halimbawa ilang i-broke ilang kasunduan or nasila i-violate sa property na sila walay permission sa other families mo to. Mahimo na nanay mga dispute nga mahitabo sa and if next day bana. The role of international nowadays, which we see, the main role of international law is to promote global peace and prosperity, which nowadays, murag kakakita na nato ang epekto sa international law because punggan nila ang ini dispute or opposing country nga, murag na sila mapunggan na nila because nanay International Court of Justice sa United Nations nga dito na hearing ang usa ka kaso or isa ka reklamo sa isa ka country. Ideally, international law is accompanying institution act as a bond to smooth over opposing interests the nation may have. Sa nga to, na natin international law, kung na may mag-oppose nga team, nga country, daanay kuan mo salo nga dirita mag judge or mag kanang ikuan nila mga dispute. Pero international law, isa pud silang weaknesses sa international law kay even though ma-hearing na ang kaso or nanay magatag-tag example para sa Philippines ang China dispute sa borders or sa island nga gikuha sa China, di gyapon mapunggan sa international law ang China nga kuhaon gid ang Scarborough Shoal nga giangkon sa China. Kaya wala police force nga mopunggon sa China, which is one of the weaknesses of international law. There's no police force to stop any country from there intervene to other country. Next, reporter.
So, good afternoon, sir and classmates. So, I am going to report what is international law. So, international law refers to the collection of laws that are accepted between countries as the laws that will govern the activities that they engage in with one another. So, in a simple way, we can define international law as a body of rule established by custom or treaty and recognized nation as bending in their relations with one another. So, what if fully international law, di ba lain kay nation to nation magkatibulaag, kaning conflict. So, international law is important. So, there are two branches of international law. Jus Gentum. The ius gentum or jus gentum or in a Latin, law of nations is a concept of international law within the ancient Roman legal system and a Western law tradition based or influenced by it. So jus gentum is a law of nation or a public international law. And second is jus inter gentes. Jus inter gentes is a body of treaties, UN convention, and other international agreements originally in a Roman law concept and later became a measure of a public international law. So, jus inter gentes is an agreement between nation. So, next slide. Types of international law. First is private international law. Deals with controversies between private entities such as people or corporation which have significant relationship to more than one nation. Example is katong sa Bhopal gas tragedy, lawsuits arising from the toxic gas leak in Bhopal, India, from industrial plants owned by Union Carbide US Corporation. So that would be an example of private international law kay kay kaning two or more person man ang nagkuan kaning nag nagsabot about ana nga conflict. So second is public international law concerns the relationship between nations. This includes standards of international behavior, the law of the sea, economic law, diplomatic law, environmental law, humanitarian law, and Example ani is the Kyoto Protocol, international agreement on climate change. Many countries have agreed to reduce their greenhouse gas emissions in order to protect the environment. So, public international law siya kay it talks about the environmental issues in order to protect environment. So, the difference between private and public international law is that private is a limited to or limited nations, while ang public is applies so many. So another example for this is private mostly for business or individual relationship, while ang public mostly for peace, humanitarian, environment, and so on. So next slide. Emerge of international law. International law has existed since the early of 19th century. But before this, but before this period, there were set of rules and regulation among different parts of the country, but there were no such laws nga na-implement ana, but but in the but in the 16th century there are three thinkers and jurists such as si Alberico Gentili, Francisco de Victoria, and Hugo Gracious. These are the fathers of international law. So kana sila tagsa-tagsa nga kaning na murag ma himo ana nga time. So Hugo Gracious was the father of international law. In 1625, his famous work, the Jury Bellici Act passes. In English, it is known as On the Law of War and Peace, and he introduced the concept of law which has bending of our states, and he also formulated the law of peace which became the basic of his whole system. While si Francisco de Victoria is that he was concerned with the treatment of the indigenous people by Spain, and he invoked the law of nation as basis for their innate dignity and rights. While si Alberico Gentili is as considered of a founder of international law. So although the modern study of international law would not begin until the early 19th century, the 16th century scholars Gentili, Vittoria, and Grotius laid the foundation and are widely regarded as the fathers of international law. And second, in the 20th century, the two world wars and the formation of the League of Nations all contributed to accelerate this process of formation of international law and establish much of foundation of modern public international law. And lastly, other international norms and law have been established through international agreement during including ang Con- Convention. So, ang Geneva Convention is muna nitong na ay World War II. The Geneva Convention remained the cornerstones of international humanitarian law as the body of rule to protect the civilian and people who are no longer fighting, including diri ang mga wounded and sick military personnel and prisoners of war. So, ang purpose pud aning con- Geneva Convention is not to stop the war, but rather to limit the worst consequence of armed conflict. And unya, ang Geneva Convention is only apply to international armed conflict. So, mo dayon inanan ni mga World Health Organization and the World Intellectual Property Organization, the Trade of Organization. So, next slide. Subject of international law. First is uh delete siya. Is ay next slide siya palihog. Source of international law. So, treaties or convention are most concrete form of international law. Government as agent of sovereign states, they presented contract when they sign and ratify treaties of international convention to be bound by mutual agreement to the term of document. So, example ani is nation to nation moagtuan na nga convention para they agree kung unsa may ilahang nasabutan didto dapat na siya kaning signature para jud na ay kaning kanang para na ay pruweba bitaw nga kani siya nga nation nag-agree ani nga policy or nga rules, and then pag human ana treaties, customs, and general principles are stated as the three primary sources of judicial decision, as scholarly writing are expressively designated as the subsidiary source of international law. Pag human ng kuan, kaning sabot-sabot sila nga, example ni agree na sila. So, pag human na, hinahinay na siya nga, i-practice ana nga kuan kana nga rule hinahinay na siya i-practice ato nga nation. Once gani nga kanang murag feel na nila nga ay okay naman dai ni siya, kanang pwede naman dai ni kay ang mga tao kanang ilamang ginasunod nga rule. So pag humanin ana, public international law is combination of rule and principle governing relation between state different fields such as armed conflict. Paguman din aning kuan kat akong gingon ganina nga kan hinahinayon siya apply sa ilahang nation. Paguman din na establish na siya dito sa kaning sa dito sa convention. So muda yun na pag nanay conflict between sa human rights, the sea space, trade, territorial boundaries, and diplomatic relation, nana sila'y kaning ginasunod nga rules in order to kaning in order to protect from the conflict between nation. So, muna to siya. That's it.
Who's next?
Good afternoon, sir. Good afternoon, classmate. Wait lang, sir. Mangita sa plaster, sir. Kinag-ulan. Wait lang, tataad lang. Okay. The contents of international law. Next. What is the international consists of? International consists of rules and principles governing the relations and dealings of nations with each other, as well as the relation between states and individuals, and relation between international organization. Ang international law consists of rules and principles. One distinguishes broadly between domestic regional law. One distinguishes broadly between domestic, regional, and the public-private international law. Domestic international law stems from domestic lawmakers and regulates the life of the citizens. Domestic law, mao na siya ang kuan, the the person who makes law, or the person who helps makes law, to which is to kuan, to and regulates the life of the citizens, and particular of a particular states, and the one who control the life, ang law nga lang ginabuhat mo, which is mga kuan mo masundon sa citizens. Regional law, such as European Union, the law of regional human rights mechanism stems from regional intergovernmental institution and addresses the governments and individuals of particular geographical region or legal regime. Regional law, which mao po na siya ang is a branch of jurisprudence which seeks to analyze the growing impact of regional bodies such as European Union. Kaning jurisprudence commonly means the philosophy of law, which is to reveal the historical or moral cultural basis. Example sa jurisprudence, which is muna siya ang the court and trial. Public international law is the subject of chapter and addresses in the most general. Next. Public international law is the subject of this chapter and addresses the most general terms. Relation involving states, intergovernmental organization, and non-state actors, which includes these individuals, non-governmental organizations, and private corporations. Relation involving states, citizens confer various benefits including the right to enjoy the nationality, the right to vote, and hold the offices and participate the political process. Ang kanin pong intergovernmental organization composed of primarily of sovereign states. Intergovernmental organizations are established by treaty that acts as the charter creating the group. Example which is United Nations, World Health Organization. Non-state actors or non-governmental mo po na sila ang ginatawag nga kwan, heroes and villains in different narratives of international politics. Idealists of present non-governmental. Example sa aning non-state actor or non-governmental man siyang private military, terrorist groups. Private international law concerns conflicts. Laws may arise in cases where the domestic laws of different states could apply. For example, in cases of cross-border or e-commerce, marriages, or liabilities. Kaning public international law is kwan, which is the primary concern ani, which is with the resolution of conflict of national law, determining the law of which country is applicable to the specific situations. The law of peace regulates peaceful relations and includes such as such subject matters as international treaty law, the law of diplomatic and consular relations, international organization law, the law of state responsibility, the law of the sea, the environment on outer space, or international economic law. Kani international treaty law, mao pa ni siya formal legally binding written agreement between actors in international law, agreements between sovereign states or countries. Kaning the law of diplomatic and consular law, which a state grant to forget. Kaning the law of diplomatic, which is the grant of the fugitive embassy or regulations situated within territory of another states. Kaning consular law, activity contained in treaties dealing with trade and negotiations, legal assistance and social security. Then kaning international organization law, international law commissions as organization established by treaty or the instrument governed by international law and possessing its own international legal personality. Kaning the law of state responsibility, direct violation of international law. A state must make full of reparation for injury caused by illegal act for it is internationally responsible. Well, kaning pong kwan, the law of the sea, it concerns matters such as navigational rights, sea minerals claims, and coastal waters jurisdictions. Paraning sa kwan sa nautical charts provide the baseline mark that inner limit of territorial sea and the outer limit of internal water. Example ani kaning kwan kung bawal ka mo lapas sa Bismarck line sa laing country kay kung molapas ka makakuan ka makakos ka og makakuan ka penalty og cause of conflict. Next. International humanitarian law is the law of armed conflicts, jus in bellium, the the law applicable in war, and regulates the conduct of international and non-international hostilities. The legal regulations of armed conflicts goes back to mid-19th century, comprises large body of customary rules and series of important conventions and additional protocols to these conventions adopted primarily in The Hague and the Geneva. International humanitarian law set of rules with sake for a humanitarian reason, limit the effects of armed conflict. It protects persons who are not longer participating in war. Kani mo na sila mga katundi na pwede maka-appeal sa war kay The legal regulation of armed conflict gusto back mid-19th century. Mo na siya ang The Hague Convention and the Geneva Convention. Kaning the Hague Conventions are are to protect children from the harmful effect of international abduction by the parent by encouraging the prompt return of abducted children for their country. Mo na sila ang kaning Hague Convention mo na sila mag-protect sa mga bata through abductions by abductions sa parents. Kaning the Geneva Convention sa serious international treaties concluded in Geneva between 1864 and 1949 for the purpose of ameliorating the effects of war and soldier civilians. International humanitarian law regulates, among other things, and methods means protection of certain categories, persons. Para kuan. Next na.
Kani sir, kay Tiara si sir. Wala si Tiara karon sir. No?
So, didn't you report? Who will report this topic?
Kay Tiara unta ni sir, pero wala man siya karon.
So, what will happen? Who's next?
Banamita na kami tulo sir, humana na mo part sir, pero ang uban ko wala man karon.
So, Jordan?
Yes, sir, kaya naghatag mo sila og report nila, sir. Nya, wala sila na nung sir ba?
Mm-hmm. Okay. So, questions, clarifications, addressed to the reporter? Okay, I'll throw the first. Okay. Yes, Mandol. What's your question?
So, di ba, the topic of the Grover Group focuses on the international law. So, what is the biggest issue that we face kumbaga, what's the biggest issue this face nga nagamit ang international law, sir?
What's your question? What is the biggest issue that
Kuhan nga nagamit gid ang kumbaga nag-occur ang international law.
I didn't get your point. Can you state what particular instance?
Kuhan, sir, what I mean is kanang kumbaga isa nga issue ang nga issue pinakadako nga issue gid nga di ba sir, sa United Nations nga nagamit ang international law.
That involves international law. Like
Yes,
for
sir.
example, in the United Nations.
Isa sa mayroon po na ako nga murag isa sa pinakadako nga na-contribute sa international law is ang pagless sa halimbawa ang pagless sa paggamit sa nuclear bomb karon nga kuan murag kalimot ko sa convention nga nahitabuan na sir, pero murag na convention nga nahitabo nga mag-less ang di ga pwede gamiton sa war ang kuan atomic bomb mga atomic bomb sir. Tas isa pud sa dako nga contribution nga nahitabo sa nga kuan sa international law is the Treaty of Paris in 1783 between Great Britain and side of America and others allies, which this end the War of the American Revolution. Bona ang isa sa mga contribution sa international law makes every country to agree or to end kana murag ipagkasundo sila sa ilang dispute or sa ilang conflict. That international law.
Okay, that's good. Badrudin to?
Oh, yes, sir.
Okay, very good. So basically, when we talk of international law, this is different from a domestic law, right? So the first thing you need to understood first is that what is the difference between an international law and a domestic law, okay? So when we talk of domestic law, these are the laws of our country, okay? Either the maybe the highest form of our law is of course the Constitution, that is considered as a domestic law, and then our criminal law, our civil procedure, our criminal procedure. That is an example of a domestic law. Why? It is because it is only applicable within our territorial boundaries. That's why it is called domestic. But when we talk of international law, this is this law governs the relationship between independent states, right? So take note that every state in the world is independent. Okay, so there is sovereignty or independence among every state. We already discussed it in our previous meeting that every there must be a somehow a relationship, right, among the states in the world, and that is governed by international relations. And this international law will took place if there is already an agreement, meaning there when we talk of agreement, there's already a meeting of the minds between the, the international organization or meeting of the minds between the members of representatives of different countries. And this will, international will establish a, or be able to regulate how they conduct their relationship with one another among states in the world. So a good example of this is what the reporter said a while ago, if you were listening and if you've read the book, our book, is that those pronouncements by the United Nations, these are example of international law. Okay, even the charter itself, the charter, the one that makes the United Nations, is an example of international law. And in Section 2 of our Constitution, we provided that international law form part of the law of the land. What do you mean by that? We believe that if, generally speaking, those generally accepted principle of international law will become form part of the law of the land. Remember that in our country, who's the one that makes the law? Okay, between the three branches of the government, it is Congress, right? It is the legislative branch of the government. Supposedly, they are the one that is making the law domestically in our country. But who makes international law? Okay, Kinsa, anybody from the group? Kinsa ang make sa international law? Kung sa domestic law, ang gabuhat is Congress, like in the case of the Philippines. How about international law? Kinsa may gabuhat ani? Who makes?
Ang each president, sir, sa
Jalil?
ay, salamat po sa tayo. One, sir, from this, sir, sa international law kay domestic. Ang kabuhat sa international law is kanang, it's kanang, kalimut, sir,
Ha?
dili,
Ah, Kinsa?
one, sir, kanang, kalimut na sa
Yes, Jacob. Thank you, Jalil. Jacob, you're raising your hand.
Sir, I guess there is a
Hmm?
sir, I guess there is a chamber between the night chamber siguro ang United Nations, sir, and then the rest of the member of the United Nation will going to agree if kung
Hmm.
ganahan ba sila na nga nga proposition nga concern nga law.
Mhm. That's correct, no? So basically, in the case of the United Nations, of which the next group will, because the topic of the next group is about international organization, and one of the famous international organization is of course the United Nations. And in the case of the United Nations, there are organs of the United Nations. Like for example, I've already said this to you many times in our previous discussion. United Nations Security Council, the resolutions coming from the UN Security Council, or like for example, in the United Nations General Assembly, this resolution is considered as international law. So as what Jacob said, there is a chamber, or there are a group of people that created this certain resolution that will form part as an example of an international law. So there are law, in the case of domestic law, mo gitawag na lawmakers. Okay? But in the case of the international setting, somehow they call them diplomats, di ba? In our previous discussion. Okay, a diplomat, of course, is a representative of a member states. Okay, so as what the reporter said a while ago, an agreement to cease a war, an ongoing war, is another example of an international law. Okay, because the parties involved, okay, in a war who opted to stop it. Okay, they agreed to stop it, and that agreement or a treaty, that is an example of an international law. Okay, another very concrete example of an international law is um, um, sa may concrete example yeah, the pronouncement of the UNCLOS, or the United Nations Convention on the Law of the Sea. Okay? Kanang UNCLOS, or the United Nations Convention on the Law of the Sea, that is an example of an international law. And that in the UNCLOS, if you've read the UNCLOS, that states it states the different provisions on countries, like for example, archipelagic states, like for example, the Philippines, Indonesia, Japan, kanang archipelagic state mo ng mga nasod nga gipalibutan og bodies of water. Okay? So in the UNCLOS, because not all countries are bounded by waters, right? There are landlocked states. When we talk of landlocked, of course, wala sila wala sila gipalibutan ng tubig. So this UNCLOS is only applicable to those states na gipalibutan og bodies of water. And an example of that country is your country, the Philippines. So those countries that agreed to the provisions of UNCLOS, they are considered as parties, state parties, meaning kita nga mga nasod ni-agree ta kung unsa ang mga statements nga nakasaad sa UNCLOS. And one of the agreements is that, and even China, okay, Vietnam, they are parties to the UNCLOS. And siya nakasaad dito, okay? From the baseline, unsa lang baseline, mo nagitawag nato nga baybay. I will show you Philippine map. I'll give you an example. See. Ako i-share ha. Makita ninyo ni na picture? Makita ninyo?
Yes, sir.
Okay.
Yes,
okay. So like for example, in this map, okay, in the UNCLOS, or the United Nations Convention on the Law of the Sea, the territory of a country, so the UNCLOS is an example of an international law, and part of the provision of that is on how are you going to kumbaga, how are you going to establish the territorial boundaries of a country? Because you know, territory is very important. That is one of the, of course, ginaawayan nga mga nga part or element of the state, right? Aside from people, sovereignty, government, okay? A territory is a very important. So there are four aspects of territory. Okay, of course, the land, the space above the land, okay, and of course the bodies of water surrounding your land, okay. So if you look at the yellow line, the blue line here, okay, the blue line, this is considered as our territorial sea, right? Because nowadays, if you look at the news, there is rising issue or tension between China and the Philippines, right? So, based on the UNCLOS, okay, our baseline, mo na gitawag nato nga baybay, kani nasa sulod nga line, yellow line. Mo nang ato ang gitawag nga baseline of our territory. And the white, okay, the white color or this bodies or sea, body of water in white color, this refers to our archipelagic water, meaning we are the sole country that can conduct fishing, that can exhaust all our economic activity in this archipelagic water. And the blue line, which is 12 nautical miles from our baseline, this refers to our territorial sea. And primarily, being a territorial sea, according to UNCLOS, kita lang gyapon ang exclusive nga makagamit, makapanghimulos ani. And then, musulod na pud ka from the baseline, another 24 nautical miles, meaning kaning yellow line, this refers to our contiguous zone. The same with territorial sea, we are the one that can exclusively utilize whatever resources found in our contiguous zone. Now, 200 nautical miles from our baseline, that is now considered as our EEZ. Okay? EEZ, mo na gitawag nato nga exclusive economic zone. And then this one here, the red line, this is referring to our continental shelf. Kung yung continental shelf, that is the land under or the land under the ocean or the sea. Okay? And of course, kita gyapon ang pwedeng manghimasok dara. Now, the problem now is that China is of course claiming that the entire West Philippine Sea is part of their... naglinog. Naglinog ba?
Yes, sir.
Naglinog sa inyo, class?
Wala din, sir.
Wala.
Yes, sir.
Naglinog, sir.
Sige, hinay naman. Can I continue?
Yes, sir.
Okay. So the problem now is that within our exclusive economic zone, under ang Kalayaan Group of Island, the Spratlys, the Scarborough Shoal, nasa within the 200 nautical miles na EEZ sa Philippines. And that is in conflict with the claim of China, and they are referring it to their historical right daw. Okay? Because China believes that part of not part, but the entire South China Sea is part of their territory. This is now, here comes the problem kung maingon ka og international law, because not all state parties who agreed nga ilang i-follow ang isa ka international law, like for example UNCLOS, na mo follow sila, because as what Badrudin said a while ago, there is no police. Okay? Walay police nga mag-enforce sa gitawag na international law. Okay? Nasabtan ninyo, who can enforce now to claim that the Philippines has the full right here within our exclusive economic zone based on the UNCLOS? Kinsa may mag-ingon? Wala, because you cannot dictate China. You cannot dictate also the Philippines. What we can do now is just a pressure coming from the international body, coming from our allies, like for example, the United States, the European Unions, and the rest of the world that are favorable to our side. Okay? Inana siya. That is why one of the downside of international law is that you cannot force those parties to follow immediately. Okay? Kumbaga, unlike in the domestic law, we have our law enforcers. Okay? We have our law enforcement agencies na gapatuman sa ato ang mga law, sa atong mga domestic law. So kung naakay crime nga makomit, automatically We have the Philippine National Police, we have the NBI, we have the LGU that can bound you. Okay? Nga dapat since naman kay crime nga na-commit, then there will also be punishment nga i-render nimo. Okay? But in the international law, wala inana. Although there is court, for example, the ICC, International Criminal Court. But kung namang court or gitawag nato nga tribunal, dapat ang mga parties mag-agree nga whatever the outcome of the tribunal inyong dawaton. But in the case of the Philippines versus China, wala man ni agree ang mo nang claim sa uban, di ba? Based on our previous discussion, Commander Masako ang in Polsai, one of the downside of because they're claiming that the previous administration under Aquino, they believe that they won in the International Tribunal on the law of the sea, that basically ato gyud daw ang exclusive na jurisdiction within the West Philippine Sea. But in the tribunal, China did not participate in the tribunal. So kumbaga one-sided siya. Unlike in the domestic law, kung makasala ka, makita nimo if it is a criminal case, halimbawa De Los Reyes versus people of the Philippines versus De Los Reyes. So that is an example of a criminal case because you De Los Reyes versus people of the Philippines. Pag people of the Philippines gani, criminal na siyang case. But for example, Nicosia versus De Los Reyes, that might be a civil case. So that, because when we talk of criminal case that involves, of course, part of the resolution later on would be punishment in imprisonment. But if it is a civil, there might be a possibility nga only payment of damages, civil damages, inana. But in international law, in a tribunal, okay, or a court of justice that was formed in order to implement an international law, one of the requirements is that both states or both parties must agree to accept that whatever the outcome of the tribunal or decision of the tribunal rather, they will obey and follow. Okay? But in the case of China versus the Philippines, wala nag-follow ang China because they did not participate. They did not agree that they will put the case in a tribunal. Only the Philippines filed it before the international tribunal, but China did not agree to participate. So you cannot, kumbaga, dili mo ma-force ang China to follow the decision of the court because they did not participate in the first place in Annexia. Okay, that's downside of international law. There is no law enforcement. Okay, only international pressures, etc. Okay, nasabtan ninyo?
Yes, sir.
Si Jalil lang.
Nasabtan, sir, nasabtan.
Kinsa to? Kina?
But, sir.
Questions, clarifications. Our topic today will be connected with the next group's topic, okay, about international organization. Because the proclamations, decisions of international organization are considered as international law. Because if a country is a member of an international organization, for example, UN, you are bound to follow the pronouncement. Okay? But as to the enforcement, okay, diya maglisod. Like for example, UN SDG, okay, United Nations Sustainable Development Goals. This is somehow an example of an international law. But not all countries is following what is the provisions of the UN SDG. The majority, yes, okay. Although ang uban mga nga provision dili applicable sa ila ba. Okay. So for example, zero hunger or no poverty. Is it applicable to wealthy states or countries? Okay. Dili man, di ba? Muna nga kasagara pud mga like for example ASEAN, the agreements among the 10 member countries of ASEAN will become considered as international law. Okay, but as to the implementation, it will only be implemented among the 10 member states. And hindi mo siya pwede implement sa mga parties that involved in the organization. Unsa pa? Question? Wala na. I'm done. Ugma na siya. Kaya na ka? Okay na mo? How are you, by the way? How's life? Turn on your camera, Dovey, para makita ta mo. We will check the attendance. I will check the attendance. Check attendance na. So, grabe good, no? Mamulbus good. Okay. Okay. Okay, turn on your camera. We will have a picture taking. Okay. 1, 2, 3. Smile. Another one. 1, 2, 3. Smile. Wala kay camera ba din? Na. Sige. 1, 2, 3. Smile. Okay. So, see you tomorrow for the next group presentation. Isang group 6. Na-adere ang group 6. Kasi yung leader.
Si Mira, sir.
Sige.
Nabaho.
Wala siya diri karon.
Chim? Are you there?
Char.